Hey guys, it's Karalynn. Welcome back to the podcast. Today we're going to go over a topic that I know has been in the news a lot about the rules changing and who is an independent contractor, who is an employee, and why does it even matter, right? Why do we have to make sure that we get it right? So, the current rule, effective March 24, is the six-factor test, and this is a six-factor test that was in in effect before Trump and is now back in effect. So there's six things that the court will look at, and this is on the federal level, right? There are some states, a very few states, California being one of them, that have their own set of rules that may be stricter than the federal rules. So make sure we get state specific on those too as well. But from the federal rule, which is what most states abide by, is these are the six different factors they're going to look at to determine if somebody is an original contractor or an employee. And we'll get into why that matters here in a second. All right, so the first factor is the opportunity for profit or loss depending on the managerial skill. So the person you're hiring, if the business does better, are they going to get paid more? Do they get some share of the profits? Is this a situation where, like I said, the business does better, they'll get more money? Or is it someone who, no matter what the business does, they get the same salary, right? If it's more towards no matter what the business does, they get the same salary, that would be more towards an employee than an independent contractor, right? Because the person has some skin in the game besides just their paycheck. So that's the first one. The second one is investments by the worker and potential employer. Okay, so is this one just someone just coming to work, signing, aren't really investing anything besides their time and getting a paycheck in return? Is there so that would be more of an employee, right? Somebody who is investing in a company as a part owner or, has a share in the stake of the company would obviously be more towards the independent contractor side, right? So are they just there getting a paycheck? Really didn't make any investment, they don't own any stock or anything like that. Or you're just, that kind of person would be more towards an employee as opposed to someone who comes into a business or even a sub part of the business, and they're investing their own money, right? If they invest their own money, that could more likely be considered an independent contractor. All right, the third one, the degree of permanence of the work relationship. So does this, can this person just be fired? One day they're not doing their job, you can let them go. That tends more to be an employee, right? As where someone who's invested the company, you can't just fire them, right? They have, the relationship is more permanent. It's not just an at-will employee, right? They have more stake in the game. And they're, they are, are they mentioned in the bylaws of the company? Are they mentioned in the incorporation docs? That would be somebody that could be considered more of an independent contractor. Number four, and from my experience, number four is probably the biggest one that the court will look at, is the nature and degree of control over the performance of the work and the working relationship. So what does this mean? Especially in the world of construction and subcontractors, right? So if the person is only working for you, you tell them when to show up, when to leave, they use your equipment. If you're the one who's controlling everything that they do, then they're probably an employee and not a subcontractor or an independent contractor, right? So if someone who is an independent contractor or, considered a subcontractor would have other clients besides you, right? They were doing other jobs just besides yours. They show up on the project according with their schedule, not yours. As far as time of the day, and they can leave and go to other jobs. You have somewhat of control. You give them like a scope of work for the job that you're working on, they'll get that done. But at the same time, they could be working for other home builders, other remodelers. That situation where they're working for other people is more likely to be an independent contractor and a subcontractor, right? Too. And this is also the importance of, if you truly have a subcontractor, having a subcontract agreement that really puts some evidence behind the fact that who's in control of their work is them, not you. Although you give them work to do, they're really in control of, how the work goes, getting it done, and you're not the only person that they work for. So they might have multiple subcontracts with multiple people. That would be somebody who's definitely an own subcontractor too. And this, if they like, another good factor is, does your subcontractor own their own business, right? And so you're actually paying their business. That's another factor of this is truly an independent contractor and not an employee, right? So this is the big one, the level of control. The less control you have over somebody, the more likely they are to be an independent contractor or truly a subcontractor, right? Number 5, the extent to which the work performed is an integral part of the potential employer's business, right? So is this somebody that it has a role that's very important, right? That you can't just find somebody else very quickly to replace. And, like, so like your subcontractor that does the AC work, whatever, he's an integral role to getting that AC work done, as opposed to like somebody in the office processing bills and sending out bills. That's less integral to the business. I know it's still important, but how essential is it? And could the business survive if they left? And could you hire somebody else very quickly to replace that role? And the 6th one is the skill and initiative of the worker, right? The more skilled they are, the more initiative they have, the more likely they are to be considered an independent contractor. Like if they're working for you, they're still out looking for other jobs to get, other projects to work on, or how long have they been in the trade? All of those things. The more skilled they are, the more independent they are. Those tend to be points towards being an independent contractor as opposed to an employee, right? An independent employee can be so minimum wage, answering phones kind of thing. That's not, a high skill, but still an important job. But as far as being considered an employee or an independent contractor, the higher skill, the more on their own they are, the more likely they are to be an independent contractor. So these are all the things that a court would take into accordance when really determining when somebody's an independent contractor or an employee, right? The more control you have, are they just salaried payroll people? Those people are going to be employees, right? If you have all the control, you show them when, you tell them when to show up, when the day ends, they're using your equipment, they're using your tools. Those people are going to be considered employees, right? And so why does this even all matter, right? Because there's hefty penalties and fines for doing it incorrectly, right? So a lot of the times what I see people do is they just think if they issue someone a 1099, then they're considered a subcontractor or an employee. And that is not correct, right? Just because you issue them a 1099 doesn't really mean anything besides the fact that you decided how to pay them. But they very much could still be considered an employee. And what happens, right? So if somebody is truly an employee and you're paying them as an independent contractor, what would happen is normally it would be like a lawsuit filed in federal court saying, I was misclassified, I was an employee, I wasn't paid overtime, they didn't withhold the proper amount of taxes because you were just paying them as a 1099. And so everybody thinks, okay, well, if that happens, I'll just settle it and we'll take care of it then. The problem is once you enter the federal court system like that, the first thing the federal court does is open up, you have to turn over your books and records of who was a current employee or has worked for you within the last 3 years, right? And what they do is the court or the opposing counsel, the attorney that that represents the party that's suing you, sends everybody on that list a notice saying, hey, you may have been misclassified. We have this lawsuit to investigate the classification of employees. If you think this happened to you, please, let me know and you can join the lawsuit, right? And so no, they're really not going to consider settlement until that step is done and they see who's going to be added to the lawsuit, because most of these attorneys work on contingency fee. So the bigger they can make the pot, the more money that they're going to get, right? So they're really not even going to consider talking settlement until they know who else is potentially out there. And then who, once that notice is sent out, who wants to join to see if they were misclassified, right? So this becomes a much bigger problem. Attorney's fees, it can become a huge problem. There's nothing you can do while you're in it to stop it, right? So once everybody's added, then they can talk about, how much potential overtime you would owe them, plus penalties and interest. All the time you're paying your attorney for representing you in this and going through all the paperwork with the other side and trying to really figure out a number that you owe and then trying to negotiate from there. There's really not a whole lot of negotiation. from the books and records, they'll pull out the numbers that you owe, penalties and interest, and then you'll have to pay it off. And sometimes it can be substantial, right? And that's to say that if you're in a situation, don't ever wait to fix it, right? If you are hearing this and you realize, oh shit, I have these people misclassified, talk to a qualified lawyer. Let's get a plan together on moving people over to the right direction, right? Don't wait till something like this happens. It'll be cheaper and less painful to fix the problem once you realize it's a problem that needs to be fixed. You can't just 1099 someone and say that, oh yeah, they're just a 1099 employee, they're an independent contractor. No, because if you really have all the control and they're only working for you on an hourly rate or a daily rate, those people are going to be considered employees and not independent contractors, right? So, another, besides the federal wage law rules, where this can become important too, is that if somebody gets injured, right? If you have them classified as an independent contractor, they're not going to be covered by your workers' comp. And then we have a lawsuit for injuries and damages that your general liability insurance won't cover, right? And so if there's some question, let's talk to a lawyer. If you really do have independent contractors or subcontractors, I would highly recommend, for a multitude of reasons, getting a subcontract, right? A subcontract, like here in the office, we do a subcontract for a flat fee, 5 business days turnaround. I think it's $2,800. And you can have your own subcontract. And how our subcontracts work is that it's a master sub, right? So the master part, the subcontractor sign once. That deals with the insurance, the not paid unless the work is, approved by you and the owner, and that you get paid. Classifies them as an independent contractor, and that they're responsible for themselves if they get hurt, or any of the people that work for them and you're not. Just sets forth a standard of work that you have to accept before they can be paid, and really protects you in situations of wage claims. Also will protect you if you have workers' comp and they in an audit and they see that you have subcontractors and you don't have subcontracts, they will classify them as employees, and then your workers' comp bill will be huge, right? And so having a subcontractor turn over them, no, these guys are really subcontractors, will make your workers' comp bill a lot less too. If somebody gets injured, that's another huge one. And then, the right to payment, right? I have a client right now who is suing the owner for payment, didn't have a subcontract, because he hasn't been paid. He didn't pay his subs, right? But now the sub is suing him and he's got to pay him, even though he hasn't been paid. And something like this would prevent something like that from happening. So if you don't have a subcontract, I highly recommend. So the master part, the sub signs once, and then for each project, you just issue them a work order of the work that they're doing for that project, right? So something you should you should invest in to protect yourself, protect your company, because the danger of not having one or misclassifying somebody can cost you hundreds of thousands of dollars if they go back 3 years and you've done it wrong for everybody. It could be a very painful thing. And if somebody gets injured on the job and they're really an employee and you don't have workers' comp for them, it can be huge. It could be enough to take a business out. So I don't say this to scare you. I say this is so you know what's out there and you can take steps to protect yourself. That's what I'm here to do, to try to lower the risk, CYA, cover your ass, so you can go out there and do the work that you love and do the things that you want to do and not worry about these things that could creep up on you. If you have any other questions, send me an email, tag me. I'm on Facebook, on LinkedIn, all of the things. Or, you can also schedule a time to talk further if you're having a particular issue. All right, guys, I hope you're killing it out there. I hope you're busy. Thanks, guys.